The push to criminalize the speech of those who dare to say anything counter narrative about residential schools, regardless of if it's the truth, has only intensified in Canada over the past week or so, all under the label of residential school denialism.
Obligation 37 of the 42 obligations identified in my final report is that the federal government must amend the criminal code, making it an offense to willfully promote hatred against Indigenous people by condoning, denying, downplaying, or justifying the Indian residential school system, or by misrepresenting facts relating to it.
I'm Drea Humphrey with Rebel News, and joining me today to discuss what the heck residential school denialism is and why the term has already gone too far is criminal defense lawyer Jim Heller, who, along with his colleague Mark Barry, were recently branded residential school denying racists for bringing forth a resolution calling on the Law Society of BC that governs them to adhere to facts and evidence by correcting its mandatory Indigenous intercultural course to stop teaching lawyers that there was a discovery of an unmarked burial site containing the bodies of 215 children on the former Kamloops Indian Residential School grounds, and instead accurately teach that it was a discovery of potential unmarked graves. The Truth and Reconciliation Commission said it best. How can people reconcile with each other when they don't know the truth? So why then are forces like the federal government's NDP Leah Gazin, Special Interlocutor for Missing Children and Unmarked Graves Kimberly Murray, and the state-backed media trying so hard to keep falsehoods alive? Falsehoods like claiming that wanting transparency over unmarked grave claims is hate against First Nations or residential school denialism, even when some claims like that have already been debunked when a shovel hit the ground, and others, like the Kamloops Band's 2021 215 buried kids discovery claim, have yet to dig or find a single body, despite accepting close to $8 million tax dollars associated with making the claim. The disinformation is so strong regarding the 215 that schools are still teaching it to our kids as though it was fact. Heck, even ChatGTP pushes the false narrative, as seen here when out of curiosity I wondered what it would tell me and others if it was asked what Kamloops is well known for, and first on its list is the discovery of the remains of 215 Indigenous children. Now, of course, I had to set the record straight with the AI and lay down the facts about why its answer was incorrect, to which it replied to me by telling me I was correct. But sadly, attorneys Jim Heller and Mark Barry's attempts to do the same with the Law Society of BC, which citizens rely on to ensure lawyers uphold truth and integrity in legal practices, didn't go as well. Heller joins me now to discuss what residential school denialism is and recap some of what he went through for bringing forth that resolution, beginning with why the Miranda Dick eco-criminal appeals case I've previously reported on was a key reason for why the duo felt the Law Society's training needed to be corrected.
So the name of the case is Dick, R.V. Dick, and it's an appeal of a sentencing of a woman by the name of Miranda Dick. Right. She was sentenced back in February 23 as a pipeline protester, and she's Indigenous. And so part of what happened at her sentencing was that her lawyer introduced to the court a lot of her GLADU factors, as they're called, her Indigenous heritage contextual things that the court should consider. And in the course of doing that, he referenced the remains of these 215 children that had been unearthed in Kamloops. And the sentencing judge at some point said, well, not really. I mean, that really didn't happen. And so they have a little bit of a discussion back and forth. And he kind of resolves from that. And the judge at that point uses the word potential. It's like potential unmarked graves,
Judge
right?
Fitzpatrick.
That's right. So anyways, what happened, apparently, I'm getting this from the Court of Appeal decision. So what happened was that the body of the court had a bunch of people that were supporters of Miss Dick, and it exploded. People started calling the judge racist and denialist, who knows whatever else they were calling her. And the sheriffs had to remove them. It's a really unseemly moment in court. It shouldn't happen. So anyways, it goes to the Court of Appeal, and this is the thing. The lawyer, her lawyer, felt somehow justified in not letting it go at that point, but going to the Court of Appeal and arguing further, saying that the judge got it wrong, and actually arguing that her sentence, which was long served, but still kind of on a point of principle, that it be set aside on the basis that the judge was biased. And I don't, it seems from the Court of Appeal decision that he also called the judge, if he didn't call her racist, he suggested that she was a denialist, which is
engaging in denialism.
Term. Right. It's an ugly term of sensorial term of art these days. I'm sure we'll talk about that in a moment. Anyways, the Court of Appeal has 3 judges, and the judge that wrote the opinion happens to be the Chief Justice of the province. His name is Len Marchand. And Justice Marchand is also Indigenous. And in his opinion, he wrote that he reviewed kind of the history of what we understand about the unmarked graves generally. And he notes that even the Truth and Reconciliation Commission and the band itself at this point, they don't go so far as to say that they've actually found bodies there, because they haven't. And so he says, look, the word potential is the right word. It's a word that was used by the TRC. It's a word that the band itself uses right now. It's the right word. The judge didn't do anything wrong, and he dismisses the appeal. There is no reason to think the judge was biased, so he dismisses it. So I thought, I'm going to do something here. I'm going to write to the course providers, because it's the only way to contact them, and I'm going to ask that they please amend their training to make it fit with what our state of knowledge is and what even our Chief Justice and our Court of Appeal says. I thought it's a bit of a no-brainer. So I wrote them, and they didn't get back to me. And so I wrote them again and asked them, did you not get my email? Because you say that you're going to respond. This is the only way to communicate with you. And I didn't hear back from them again. And so then I wrote them a 3rd time, and I said, what's going on? And I think these were really civil, clear emails. I said, here's what the training says. Here's what the Court of Appeal says. This is like a really important, inflamed issue. It matters to all Canadians. I just want to say something here. People have made the point, some people have argued that this isn't my issue. I'm some white guy. I'm like a white European Canadian settler, whatever. It's not my issue. It's their issue. It's the Indigenous issue. It's the residential school survivors issue. I don't agree with that. When you accuse someone of something, that becomes their issue too. I'm a Canadian. This is all of our issue. That's how I see it. So I own this issue too.
Well, that's a view for reconciliation, if you ask me.
Yeah, that's right. There's a lot to discuss. There's a lot to think about. There's a lot of truth to learn about, and a lot, all of this kind of is the real fertile ground for ultimate reconciliation. First truth, then reconciliation. Anyways, Law Society never got back to me. I'd written them 3 times. We have this mechanism in the Law Society. We can bring resolutions for our annual general meetings. We do this once a year, and people do bring private member resolutions. I brought one once before. I think that was bona fide. People could disagree. They say, why are you wasting your time with that? Well, you're entitled to your opinion. I didn't think this was in any way frivolous. I thought it was an important issue. So I brought a resolution to direct the Law Society to make the change, to just simply correct the training. What crystallized this whole issue for me and kind of compelled me and a colleague, Mark Berry, another criminal defense lawyer, to bring this resolution was that this Court of Appeal decision came down in July. And it was a decision that basically affirmed the fact that it's completely appropriate for a judge, or really anybody in our system, to talk about the unmarked graves as being potential. And that really flags the fact that there have been no excavations in Kamloops. We don't know that there are any graves at all. So the training that we have says to the contrary, that they found these graves. It also says that this doesn't surprise the survivors or the residential the band itself because they knew this all along. Well, those two things are at odds. So we brought this resolution to basically marry up the training to make it comport with our actual state of knowledge, which is that these are potential graves.
Survivors, families, and communities have a right to be safe from violence, safe from hate, and that's exactly what Bill C-413, to amend the Criminal Code 319, to add to the Criminal Code, in addition to Holocaust denial, the willful promotion of hate against Indigenous people by condoning, downplaying, justifying the residential schools.
In my final report that I released earlier this week, I noted that despite the well-documented reality that thousands of Indigenous children died at Indian residential schools, and that many children are buried in unmarked and mass graves, some Canadians have mounted a concerted effort to attack the truths of survivors, Indigenous families, and communities.
We're lawyers. We should care about the truth. And a lot of lawyers actually said that. I got a lot of emails and support. But it wasn't just like individual lawyers. The Law Society itself denounced this. It's kind of unfortunate. I'm embarrassed as a lawyer in this province to actually have to say this about our own Law Society, but they did. They put out a press release where they said that our motion was frivolous, vexatious, and unnecessary. And they also, the press release ended saying that it just is an indication that there's a lot of racism in the profession that needs to be dealt with. And so obviously that's implicitly accusing Mark and me of being racist.
Yeah.
And that's really kind of unfortunate. And we got that same kind of reaction from some of the other BC Civil Liberties Union, the BC First Nations Justice Council, the Canadian Bar Association, all kind of piled on that bandwagon to say, shut up. Mm-hmm. Shut up. Mind your own business. You don't have this issue. This isn't your issue. I disagree. I think this is all of our issue. It's a Canadian issue, and we care about the law. And I want to say something just from the lawyer's perspective. Mm-hmm. Like I don't want to wade into, and you're not asking me my own speculations or my own beliefs as to what exactly is the status of the unmarked graves. I don't know. Yeah. Right. But the important thing is that if by chance there are any criminal prosecutions that ever arise from this story, let's say they actually do some excavations, they find some graves and they're able to trace them to certain perpetrators, there's foul play afoot and all of that kind of stuff. Maybe myself or some of the lawyers going to be involved defending someone who's charged as a result. Well, at that point, those witnesses, whatever live witnesses are brought to court, they're going to be subject to cross-examination just like any other witness. And their word isn't going to be sacrosanct. It's not. We're not going to be in a situation of some sort of exalted, protected level of credibility. You know, in other words, no one's going to be called a knowledge keeper when they take the witness stand. They're just going to be a witness. Right. And their evidence will be tested like any other witnesses. And that's our system thrives. It doesn't thrive. It depends on that. And I'm really, really concerned about the encroachment, the kind of ideological encroachment on this really nice, simple, but powerful, strong, centuries-old legal system that we have that just depends on this way to test evidence, and it's evidence-based, and I'm really concerned about that.
Well, and you are supposed to be, you and the rest of your colleagues are the justice defenders. We need you to be able to know what is reality, if anything. I want to talk about the actual vote itself that came down. It looks like it was defeated with 1,683 voting against and 1,499 in favor. You know, pretty close to half. Sorry?
48%.
Yeah.
48%.
What were your thoughts on that outcome? Were you
I was blown away. I thought that they would have intimidated more people than they did. Mm-hmm. There were also 590 abstentions. Oh. So you have to understand that everybody that voted is going to be identifiable by the Law Society. Yes. we get individual identification numbers, and even though the other people wouldn't have known how you voted, the Law Society would.
We have enough evidence, the TRC and survivors' testimony, there's enough evidence that there are burials on these institutional grounds. We don't have to put pictures of children's remains on social media or on news webcasts and broadcasts for people to believe that there are children that died in these institutions and they're buried on these grounds.
So as a criminal defense lawyer who is now being told, no, we're going to continue training the lawyers that it is true that that discovery happened, and now seeing that our elected official is trying to criminalize anything against that, essentially, that's what it seems like. What are your thoughts on that? Am I overreacting when I say that's absolutely terrifying?
No, you're not overreacting. And it's also particularly concerning that this same misguided member of parliament actually tabled an earlier motion to have the residential schools declared genocidal, and it was affirmed, I think, unanimously in parliament, which is like shameful. But the distinction there is that that was just a declaration. This is like to actually change the criminal law.
Yes.
I guess it relies on us being true to kind of just some fundamental principles. Mm-hmm. Principles for lawyers are that we care about truth, we care about evidence, we care about reason, we care about rational discourse. That's kind of it. Mm-hmm. I think it's disgusting, actually. I'll use that word, that member of parliament felt so justified to be able to kind of do this dangerous kind of virtue signaling and use our parliamentary process to do so.
If you haven't already done so, go to kamloopsdocumentary.com and watch and share our investigative documentary that came out around the 1-year anniversary of the 215 claim. It tells the truth of what we know so far, and we've made it available to you for free. But if you appreciate the work that we do, consider donating what you can while you're on that site.